So guys, I'd like to introduce to you now Mark Harrowell. Mark is the Deputy President and Division Head of the Consumer and the Commercial Division of the Civil and Administrative Tribunal, NCAT, and has held that position since 2019. As a lawyer with nearly 40 years experience, he has been a partner of large Sydney law firms, participating across all areas of litigation, including commercial litigation, where he specialises in construction and property law. In 2012, he commenced as a part-time senior member of the Consumer Trader and Tenancy Tribunal, the predecessor of NCAT, and was appointed as full-time Deputy Chairperson, Determinations, to that tribunal in 2013. On the formation of it in 2014, Mark became the principal member and listed manager of the Consumer and Commercial Division. In 2016, he was appointed principal member of Appeals and continued in that role until his appointment as Deputy President in 2019. So, Mark, I'd just like to hand the floor over to you and thank you for being our guest speaker tonight.
To cover off on 5 topics: what is expert evidence, the role of the expert witness, the preparation of expert reports, what we call conclaves, which is a meeting of experts, and giving evidence at a hearing. I'm happy to take questions at the end, and I'm certainly happy to identify for you the sorts of issues that we regularly see in the tribunal in the presentation of expert evidence. First of all, a definition of expert evidence. What is it? Expert evidence is opinion evidence which is admissible as an exception to the opinion rule. The Evidence Act, which applies to proceedings in the court, in a court, says this: if a person has specialised knowledge, so that's the first part of it, based on the person's training, study or experience, so you don't need to have a degree, the opinion rule does not apply to evidence of an opinion of that person that is wholly or substantially based on that knowledge. Now, that, just to bring that into focus, that's not just common knowledge, it is specialised knowledge based on training, study or experience. Now, in terms of proceedings in the tribunal, the rules of evidence don't apply. The tribunal can inquire into any issue in the proceedings in such manner as it thinks fit. There are, and when I'm talking about proceedings in the tribunal, I'm just talking about proceedings in the Consumer and Commercial Division, particularly tonight building cases that, of course, we have jurisdiction to determine. In terms of the obligations of the tribunal in relation to that receipt of evidence, the rules of evidence, as I said, do not apply. However, we need to give everybody a chance to be heard and have their submissions and evidence considered. If you like, that's the natural justice proposition that lawyers often talk about. In relation to claims over $30,000, however, we also have what's called Procedural Direction 3, which operates. That provides for, that procedural direction regulates the provision of expert evidence, and I'll come to talk about some of the things that are relevant there. Experts we often see in the tribunal have a misconception of what their role is. Experts do not decide expert issues. All decisions are made by the tribunal. The expert's role as such is to furnish the trier of fact with criteria enabling the evaluation of the expert's conclusions. I can tell you it is very frequently the case in the tribunal that the experts just offer an ultimate conclusion about what they say. That usually will not pass the test of satisfactory expert evidence, and frankly it provides little or no capacity for the tribunal to review and make a determination about it. So what does the expert have to do? First of all, the expert has to explain and prove as necessary the expert's qualifications or their experience in enabling expressions of opinion to be made. Now, sometimes, of course, that might be simply stating your qualifications and the work, stating your industry experience and your practical experience, and providing other information concerning jobs done. And of course, the tribunal, the first matter the tribunal needs to be satisfied of, or the court needs to be satisfied of, is that the person who's expressing an opinion actually has the qualifications which they're asserting. The next thing that's critical in the provision of an expert opinion is to state the facts and assumptions about which the opinion is being offered. And that includes identifying all relevant documents. Often experts make this mistake. They walk around a site, they make observations, they take measurements, they do tests and so forth, but that material's not provided to the tribunal. It might be in the form of photographs, of course. It might be in the form of some sort of test that's been done on the way through, for instance, a destructive test or a water penetration test. But all of this material needs to be appropriately recorded, recognising, of course, that you're probably not going to find a tribunal member. Perhaps a court might do it over a several-week hearing, but most of the hearings that we do in the tribunal are conducted, even for very large value claims, over a period of about 2 to 3 days. And could I just add at that point that the work that the experts do in relation to getting these cases ready is critical for us, that is the tribunal, being able to deal with issues and resolve the real issues in dispute in a just, quick and cheap manner. The next thing is that the expert's required to provide an explanation of the analysis of the facts to which the special learning has been applied. Now, I'll tell you a story in terms of one of my former colleagues, no longer in the tribunal, but when I first started, the member had an engineering issue that needed to be considered. He had 2 experts before him, one for each of the parties. Both of them were qualified engineers. The engineer who was offering the opinion for the builder offered a view about the fact that he had been designing a particular type of slab for a number of years and that he'd never seen it fail. The house, the subject of the dispute, had cracks through the walls, and they weren't just simply settlement cracks, they were cracks of significant dimensions that would indicate the movement in the foundations and that the house wasn't properly founded. The opponent in the case, the opposing expert in the case, was a young engineer, just hit 30 years old, who'd done some calculations in relation to the slab and its ability to bear a load. Those calculations, as people are aware of engineering calculations will know, that engineers love mathematics. I've got to say, lawyers don't often like mathematics. Their eyes tend to glaze over and the scriptwriter dies at that point in time. However, the young expert had done some calculations that showed the slab was overloaded in particular points, which gave rise to the shifting of the slab and therefore the cracking of the building. Now that was in essence the competing evidence, and my colleague rang me up, and I don't give answers or easy clues, even if I know what the answer is to difficult problems. The members have got to work it out themselves because that's what their job is. But I got him to tell me the story about 3 or 4 times, and finally the penny dropped. He had an expert who simply said, "I've done this for 35 years and I'm right." And another young bloke had done the calculations to show that there was actually an overloaded structure which had failed. So that by explaining those things, the young engineer's evidence was accepted over that of the person that had been doing these things for 35 years. Why? Because the young engineer stated the facts on which his opinion was based, provided his analysis in relation to those facts, the measurements and the things that he'd done, and of course provided a conclusion based on all of that material. So if you like, that's the role of the expert, is to set that out. Now, I know that it's a problem that lawyers suffer from as much as other people when one comes to decision making or when one comes to providing expert opinions. And I've always explained it to people this way. People of reasonable learning and reasonable intelligence, and they don't need to have degrees or doctorates or anything like that, should be capable of explaining in a rational sense why they're right or why the other person's wrong, and that should be capable of being analysed. And as I said, that's the critical issue for experts, that is to present their view, their opinion, based on the facts that are either assumed or proved, and I'll come back to assumed facts in a moment, and set out their opinion in a manner that allows analysis of it. It's the same test that I say members should apply when they're writing reasons. That is, why does this fact, why do you say this observation demonstrates something? You must be capable of explaining that in order to provide an adequate expert report. Now, there's a case of the Court of Appeal called Forster and Hunter New England Area Health Service, a judgment of Justice McFarlane back in 2001, refers to a case called Makita Australia Proprietary Limited and Sproul's. Again, I'll give you the reference when the PowerPoint presentation is circulated, but it's worth perhaps if I just read to you what Justice McFarlane said. As Justice Hayden, as he then was, indicated in Makita, for an expert report to be useful, it is necessary for it to comply with the prime duty of experts in giving opinion evidence, to furnish the trier of fact with criteria enabling the evaluation of the validity of the expert's conclusions. Justice Hayden referred to a decision of Lord President Cooper, a decision out of the United Kingdom. We always like to return to the old dart occasionally to come up with some legal ideas. And it says, the judge said this: the scientific opinion evidence, if intelligible, convincing and tested, becomes a factor and often an important factor for consideration along with the whole of the other evidence in the case. But the decision is for the judge or jury, in particular the bare ipse dixit of a scientist, however eminent, upon the issue in controversy will normally carry little weight, for it cannot be tested by cross-examination nor independently appraised. And the parties have invoked the decision of the judicial tribunal and not the oracular pronouncement by an expert. That's a very big word. I need to wrap my little gums around that one. And then His Honour Justice McFarlane considered to like effect that the statements also quoted by Justice Hayden in Makita of Sir Owen Dixon, former Chief Justice of the High Court of Australia, who in some writings said courts cannot be expected to act upon opinions the basis of which are unexplained. And of the authors of Phipson, His Honour said, in general, an expert may give evidence in chief as to the grounds on which he has reached his opinion, and it may be said that without the grounds, the opinion is valueless. So you need to just bear that in mind. In effect, what you're doing as an expert is explaining to the court or tribunal why you have the opinion, what are the facts on which you base the opinion, and why, by a process of reasoning, do you reach a particular conclusion. If you're able to do that, the significance and strength of the evidence becomes so much more powerful, because, as I've said before, part of the evaluation process when you've got competing evidence is to look at the weight particular witnesses' evidence should be given. An independent expert who is acting independently consistent with the code of conduct becomes a very powerful ally to a person making a complaint or making a claim or defending a claim. Now, in terms of the preparation of experts' reports, procedural direction through expert evidence applies for claims that are over $30,000 or where the tribunal directs. Otherwise, an opinion can be contained in quotations or other documents that might be prepared by a qualified person who might perform specialist services. Now we have various cases, and I see for some reason when you get the slides, there's a reference that's left out. My recollection is it's the case of Kang and Khan, which in effect says if you've got a quote, for instance, from a mechanical repairer about a particular problem with the car, if the repairer in his quote identifies the observations he's made, for instance, a cracked piston or a cracked ring around the piston, and that can identify there was no oil in the sump when he went to carry out the repairs, and therefore likely that the cause was the engine running dry and therefore the piston or the rings failing. That may be an adequate expert opinion, particularly for small value claims. On the higher value claims, of course, if you like, greater certainty needs to be provided before the tribunal is going to make an order to give away hundreds of thousands of dollars. In complying with the procedural direction, again, the provider of the opinion is to expose their qualifications, their facts, the reasoning process, and the conclusions in a manner that permits evaluation. Now, obviously you have occasions as well where a party doesn't have an expert. That is, you might have been engaged as a consultant along the way to assist in the building works. That opinion might be admissible, it might not be an independent opinion, but of course relevant in taking on these engagements, if you're going to offer yourself as an independent expert, is to make sure that you've not had a general commercial relationship with the parties to whom you're providing opinions. I appreciate experts over time tend to work with the same clients dealing with similar topics of issues, particularly where builders do a lot of building work. A lot of the large companies, the reality is they run into problems from time to time, some of their own making, some not of their own making. But if you've got those sort of associations, again, great care needs to be taken in maintaining independence. Again, the critical requirement for the expert evidence is an explanation of why the opinion should be accepted.
Yeah.
Now, in terms of requirements, particular requirements that arise under the procedural direction, first of all, the expert needs to adopt the code of conduct. That is, that the expert agrees that they will be an independent expert and not an advocate for their party. I appreciate the party's paying the bill, but you need to make clear to the folk that are instructing you that your job's not to help them as such win the case in the sense that you're an advocate or a supporter of their view. Your obligation's to assist the tribunal in making the determination, which is for the tribunal to make, namely whether or not a particular circumstance of an expert or technical matter existed, whether or not fault should be ascribed or assigned to the particular person, and so forth. Again, the expert evidence practice procedural direction requires that there be a statement of the facts and assumptions on which the opinion's based, often annexing the letter of instruction. Of course, once you're offering an opinion, you need to understand that if you're given instructions about the preparation of your opinion, those instructions will usually be produced to the other side or get a chance to ask you questions about those. So you need to pay both close regard to your instructions, but also close regard to what you need to offer an opinion about. Sometimes the instructions, through misunderstanding, sometimes by preference because people are trying to push a particular case, don't actually help you expose the real issue. So you need to look at that quite carefully. You need to state as well, which is something experts are often reluctant to do, what's outside your expertise. I can't tell you how persuasive an opinion can be from somebody who says they're not an expert in everything. Lawyers often think they're experts in everything. I know that you folk as consultants don't hold yourselves as experts in everything, but it is important to make a statement about what you are able to offer an opinion about and what you can't. It's both important for the tribunal, but also important for your client and for those that might be providing instructions to you, because it will be necessary for them to get additional opinions if that be the case. Include in your reports relevant literature or material supporting the opinion tests and examinations that have been carried out and other investigations carried out, including, if necessary, the qualifications of the person who did them. It's not unusual where one has a series of complaints about a house where you might have some engineering evidence in an next report embedded in a building consultant's report, the building consultant looking at the more general aspects rather than some special aspects, and or providing some costing about those things. So make sure that you put that together. The other thing that's very useful for the tribunal is, and the courts, is to provide a summary if the report is lengthy. Remember that you're trying to produce a document that's capable of being assessed by the tribunal, that has to ultimately form the opinion about, make a decision, about whether the opinion is right or wrong. So have a look at how you can present it in that way. The critical features of the independent expert, as I've said a few times, the paramount duty is to assist the tribunal. You're impartial and not an advocate for the party who has employed you, and you should only comment on matters that are within your expertise. You need to make, and this is probably one of the most important things that I can say to you tonight, you need to make concessions, even where they're against the interests of the party who engaged the expert. We often find, and it leads to a lot of cost and a lot of wasted time, that experts will do an excellent job at trying to avoid answering the obvious question. Everything that you do, and if you've got a problem, if you identify a problem that might be critical to your client's case and cause the whole case to fall in a heap, pardon the pun, when we're talking about building work, if you go back to what was said to you earlier concerning getting on board, it promotes settlement when you actually point out what the problems are. You'll ultimately get in the witness box. You'll be asked questions by, and usually by intelligent and well-informed lawyers, such as those speaking tonight, who know how to find the weak spots of the opponent's case. And they'll ask questions about these things. And of course, if you haven't conceded them and they're obvious concessions, that will be a problem. The other issue that I find is a critical issue in a number of the reports that we see in the tribunal, and I've got to say I find somewhat aggravating, is that often experts are told to make an assumption about a particular state of affairs, such as whether or not there was an obligation under the contract to do something. I've seen many opinions offered in the tribunal where the expert says, I was told to assume there's no contractual obligation to do work A. As a result, the expert has not offered an opinion about that. Then when it comes to costing, the experts also offered no opinion about the cost. Now, the view that I take about those things, that if that's the expert's position and they don't offer any evidence about those matters, that is the alternative scenario to the one that they've been asked to assume, in my view, they've offered no evidence to rebut the evidence from the other side about cost. As a result, the evidence, if there's only evidence from one side that's available as to cost, and it's a large sum of money, in all probability, unless there's something obviously wrong with that evidence, it'll be accepted. And one of the things that the experts do is that they try and come along at the end of the case, and the lawyers try to, if you like, put in late in the day the evidence in relation to those topics. Now, in the tribunal, you'll often find the tribunal won't permit that. We give people a chance to put on their evidence. But if they don't stump up with the evidence that's required, then they might have a problem moving forward. So think about what you need to concede. And there's another reason to do it, even if it doesn't see the light of day in a report initially. The other reason to do it is to inform your client about these things. When you climb into the witness box to give evidence, as I say, you'll be asked questions usually from lawyers who are very clever and very knowledgeable in these sorts of areas of litigation. They'll know the questions to ask, they'll know what you've done, what you haven't done, and the more that you back away from trying to assist the tribunal, the more likely it is that you will devalue your own opinion, but more particularly, you won't have helped your client at the end of the day, because when this evidence comes out, for instance, on the alternative scenario that you've not costed, that there's tens or hundreds of thousands of dollars involved, A, it won't do your credit any good, but B, it'll protract the proceedings, and C, it will likely result in the other side's evidence being accepted. Where an expert is asked to assume the existence or non-existence of particular contractual obligations, as I said, consideration should be given on the basis of the other party's assumptions, not simply the assumptions that you're asked to make. The expert's told not to respond to particular scenarios based on alternative assumptions. As I said, it may be that the effect of the report will be that it's valueless, or and the expert loses the chance to comment on the alternative assumptions. One of the sorts of cases that we see often in the tribunal where these things arise, we see a number of cases where, you know, some damages claims, one side says $10,000 and the other side says $200,000. Now, I don't think you need to be a qualified expert or Einstein to work out that either at least one of the people who are offering those views is wrong, or both of them is wrong. But that sort of disparate costing that arises, usually unexplained because people have just put a bunch of gross numbers there with no explanation as to how they got there, creates a problem in the decision-making process for the tribunal. I'd like to just move on and talk briefly about conclaves, and if you like, the usual approach this tribunal's taking to evidence. I mentioned before in relation to building cases that this tribunal usually only allocates 2 or 3 days to a hearing. I don't want you to think that I haven't been involved in long hearings. The longest hearing that I was involved in was a Supreme Court reference concerning a dispute in relation to an Olympic project that ran for 155 days of hearing. So I think I do understand what a long hearing is about. I don't think there's many people have had commercial trials that have lasted that long. Having said that, one of the issues that arose was the degree to which the experts' evidence was well organised and the way it was presented. And the side that I was on, I think we managed to get through cross-examination of all of the other side's experts in about 6 weeks. The opponent took 6 months to cross-examine our witnesses. In part, that arose because of a lack of sort of focus on what the real issues in dispute were. The reason I'm telling that little story is, one, to say to you, if you ever thought you were going to get 155 days out of this tribunal, I don't think you'll see that in a month of Sundays. But more particularly, it's what do we do to shorten them? I know that when people hear me talk about you're only going to get 3 days of hearing, that everybody thinks, gee, we're being ridden roughshod over and we're not going to be able to present our evidence. That's not the case at all. What we do is we use conclaves to try and narrow the issues and identify what the matters in dispute are. So when you're preparing your report, you might offer an opinion. You might then get an opposing expert's opinion that's completely disagreeable with yours, and then we'll ask the experts to get together and have a conclave. We usually do that before the hearing starts, but sometimes it happens during the hearing. The conclave is simply a meeting of experts to discuss and try and agree matters in issue and to narrow issues to be resolved. We also have in this tribunal, which is unique, not usually found in the Supreme Court or the other courts, is we have a tribunal member, either as a lawyer or more likely as a specialist member, such as an architect or engineer, who will help convene the conclave. Now, a lot of people think that the conclave process is about bartering. It's not, although some clients particularly might feel that way. But what we do is that the tribunal, for instance, has to determine what the reasonable costs of rectification are. When assessments are made, the reasonable costs of rectification can vary. As you know, they can vary by going out to the market and getting quotes on the whole thing. What is reasonable can sometimes be a figure in between the two extreme views. Obviously, one side might say the lowest figure because that's in their interest of their client. The other might say the high figure, but there's usually a range, and the conclave process can agree those things. The conclave process can also agree what are the reasons for the differences of opinion which remain to be determined. And usually in the decision-making process that the tribunal makes, we want to know what is the critical question. In very basic terms, it is, why do you say you are right, and why do you say the other side is wrong? Now, sometimes it can boil down to this sort of a statement. If I can give an example, I went to site, I measured the cracks on site. They were greater than movement cracks. The pattern of the cracking on the wall indicated a shift in the foundations because of the way that it happened. I did a case once which, back when I was a lawyer practicing, where brick growth, the bricks were not properly fired. Brick growth ended up pushing the side of the house out because there were no expansion joints, nothing had been cut, pushed the side of the house out by about 20 centimetres, which was quite extraordinary. I've got to say, I've never seen brick growth like that. It was a house down at Balgowlah that I had a look at, but it was one where those sorts of observations that were made gave a lot of substance to the complaints, particularly once you put the analysis of the bricks that they hadn't been properly fired and so forth. So if you can explain in detail why the other side's wrong, that's critical. Having said that, when you get to the conclave, you won't usually get the chance to have another go at it, so that the sorts of directions we make in the tribunal is for the parties to explain their reasons for difference, but then point to the analysis in their reports that explains those differences. In other words, you don't turn up and get to write a brand new report through the conclaving process. It should already be on the table. In terms of what we also do, we have adopted the approach where we get simply a Scott schedule and we put both experts in the room and tell them to prepare a report together. In other words, to do a walk around. That's a different form of how we approach things. All of these things are designed to minimise cost to the parties and minimise the time that's involved. Often we're faced with experts who are very busy, and when the room's pumping and everybody's got issues with their building cases, there's a lot of work around, particularly the good experts. And in your area, of course, up in Newcastle, it's a growing area of work, but there's still not a lot of experts that we see from your area who appear in the tribunal. But it does mean that the experts say they're very busy, and we try and find ways that avoids reports and so forth taking months to prepare. That's particularly important to us because of 48 MA and the preferred outcome being that that a party should be should be let back on site to rectify any defective work. So with the Scott schedule, with the conclaves, in mind, we're focused on trying to get the parties, experts, to work out exactly what's wrong by reference to their report. So please make sure you do put this sort of material in your reports. And I say, if the other side has made an assumption which you don't agree with, still look at whether or not their assumptions still look at whether or not you can offer an opinion based on the assumption, but by all means comment, particularly if you know facts, or can state the facts that make that assumption an invalid assumption to make. Now, in terms of giving evidence, I'd just like to deal with this briefly. Evidence can be given separately or jointly. Again, one of the ways to speed up trials is to actually have what we call concurrent evidence. It's affectionately known as hot-tubbing. Not quite as exotic as it sounds, but nonetheless an effective way. It involves usually this, that each of the experts will be in the witness box, they'll be sworn in, they'll get to make a brief statement concerning their position on a particular topic. They might have a chance to ask questions of each other or to be questioned by the tribunal or the lawyers appearing for the parties. And then usually the tribunal will again focus on what's the essential difference between the parties. So if you've been able to look at this, harping back to the conclaves, it's a great deal of, it provides a great deal of assistance to the tribunal. Again, it's not usually a chance to give new evidence or to explain a conclusion. On the other hand, some reports are extremely technical, and the tribunal themselves value an expert who's able to clearly explain complicated concepts. One of the things the experts want to do, which doesn't help, is not listen to the questions that are asked. Usually the questions are being asked because the tribunal members think it's an important question to ask. I've done many cases where parties and their experts have not wanted to answer my questions, even where I've been as blunt as saying, if you don't answer this, you might lose, because I really do need to know the answer to this question, and it's an important question. Provide succinct answers, obviously, and assist the tribunal as you can. Don't make unnecessary speeches, because again, that tends to devalue your credit, because you come across as an advocate rather than a person who's an independent expert assisting the parties. As I said right at the start, the tribunal's the determiner of all matters of fact, including contested matters about which expert evidence is given, and it will make decisions based on reasons, or based on a reasoning process. A mere statement that an expert, that they are right or have the experience over a long period of time, is of little weight, and all opinions, as was said in Makita by Justice Hayden in other cases, should be capable of being reasonably evaluated by the decision maker. So that's all that I'd like to say tonight. I appreciate it's gone on for a while, so I hopefully, one thing about being able to see people, even if they're quietly got the straw in their glass of wine and surreptitiously have a sip, is that I can see that most of you at least are still awake. So thank you very much for allowing me to speak tonight. I would like to apologise, because I was looking forward to the opportunity of coming up and meeting you all, and the work that you do is incredibly valuable and extremely necessary to the work of this tribunal and of course the court. So thank you very much for your time this evening. And if anyone's got any questions, I'm certainly happy to answer those questions.
I'd like to just unmute
yourself.
I would like to just thank you for a fantastic presentation. That was amazing.
You're welcome. And look, I am happy. I know we don't often do this, but I am happy if there's any sort of direct questions that you want to ask, you know, or any matters that you want to bring forward. We're always looking to improve our processes. As I say, the critical part of our process, I think, is the just, quick and cheap resolution of the real issues. It does require close management. It is always a concern to me about the costs that have been that are incurred by the parties. We often see disputes that, if you like, they go on for so long and the cost becomes so large, the dispute becomes one about cost. And I do very much subscribe to what was said earlier in this evening, namely that if you can do anything to help the parties get a resolution, often that's seen as something unpalatable to many homeowners to get the builder back on board. But I can't tell you how much we hear through the cases when we're looking at 48 MA about, and how much evidence we receive about the differential cost. Usually to get the builder back and to give them a go won't be any trouble to the homeowner, in the sense that they might be given a second go after everything's gone pear-shaped. There's always a million reasons why people don't want to do it, which I understand, but looking at possible settlements for that, looking at timeframes, it usually solves the problems a lot clearer and with a lot sooner and with a lot less angst. I can't tell you how many times I've mediated matters in this tribunal, and where at the end of the day, having got a solution, the parties, particularly the homeowners, but often as well the builders, are greatly relieved by what's occurred. They don't always get everything that they want through that negotiated settlement, but usually what they do is get a fix up to the problem a lot sooner, even than coming to the tribunal. Having said that, of course, we will maintain our commitment to getting cases done as quickly as we can. Could I just also say, we've talked about Zoom and the technology. This tribunal, particularly in my division, we have a strong emphasis on being able to see the parties at hearings in person. I think that is part of taking the evidence, but also it allows us an opportunity to try and assist the parties in negotiate their settlements. So hopefully it won't be too long before we get there. I'm probably not optimistic, if I'm being blunt, that it'll be in October, but hopefully by the early new year we'll see everybody back in the building and back in our hearing room. So otherwise, thank you very much for your time.
Mark, could I ask you a question? David Crease.
Yes.
What's your view? I'm sorry, I'm jumping in. I see Stan's got his hand up. I shouldn't jump in front of Stan. Go for your life, Stan.
No, go for it. Go for it. Yours will be a smarter question than mine, I'm sure.
Oh, I'm sure that's not right. Mark, what's your view on experts who give an opinion as to whether or not a statutory warranty has been breached? Is that a legal question or is that a factual question?
It's both. It depends on what the nature of the opinion that they're expressing. But as you know, David, the experts these days can give advice on the ultimate question. It doesn't make the opinion inadmissible. That is, if the rules of evidence don't apply. Often what happens, though, is that the conclusion's given without any supporting material. So that, and some of the difficult areas, as you know, that we see is whether or not something's a major defect and when it involves waterproofing and so forth. So we've got a sort of lot of twists and turns, but in some sense you end up having to give a statement about the ultimate question in order to bring it into focus. So it's not impermissible. The question is, it's usually a conclusion and the expert jumps to making the statement by way of conclusion rather than explaining why they hold the view.
Thanks, Mark.
Yes, Stan?
Yeah, no, that was a good question. My question was, you noted when we're in a hot tub, we can ask questions of each other. How does that work?
It depends on, it's for the member to decide what they need to do and to how the inquiry should progress.
Mm-hmm.
But sometimes the members don't always know the right questions to ask. And sometimes it's useful to hear what the experts, because the experts talk about these things. You know, why do you hold this view? Why did you do this? What did you see? I didn't see that myself. Some people give you evidence about didn't see it raining. Didn't see any water ingress, but of course their evidence is based on a very sunny day in the middle of a drought. Again, getting people to explain some of what they've seen, some of what they've heard and how they analyse something often helps. And the experts are sometimes the best people to ask those questions. It does speed up the process. As you know, lawyers can flounder around. They do what I call the sort of softening up, where they ask a lot of questions that don't really go to anything except credit. Whereas really what we want to know is, did you actually see any water coming in around the seal of the window? And these sorts of things, which experts are aware of as being telltale indicators of why something is likely to be there or not be there in the sense of a defect, can benefit from the questions. But it does depend on the member hearing the case. It does also depend on the parties, because often the representatives for the parties, because they've often got their own views about how the hearing should be conducted.
Thank you.
Any other questions, folks?
Mark, it's Rob Taylor. Just wanted to ask about the appeal process, and do you see many going to appeal?
Yes, building cases, because they're high value, are a fertile area of appeals. We, as you probably know, the inn to the tribunal is not that expensive. An appeal to the appeal panel for a corporate body is about $800 odd. Unlike the courts, we don't have a hearing fee or something like that. So we do see that people will actually try and challenge things. The thing to perhaps remember in relation to appeals is, while there's an appeal as of right on a question of law, you need leave to appeal on other grounds, including challenging factual conclusions. And a lot of people simply think it's a walk in the park for them just to serve up the evidence and indicate to the tribunal that they think a factual error's been made. There's not a lot of appeals that get where leave is granted to challenge findings of fact, but there are certainly cases where that's occurred. We've seen a bit of new legislation as well. 48MA as was mentioned in the earlier presentation, for a while was a fertile ground. And if you want my observations about that, and I have written some of the decisions concerning 48MA and how it operates, I know from a decision, I just can't think of which judge it was in the Supreme Court, but as you know, 48MA applies to the court as much as the tribunal. But because it involves the court making a mandatory injunction, as opposed to us making a work order, the courts have taken a slightly different approach. I draw that, I'm sort of particular with those words, because a mandatory injunction, if you like, is what lawyers call an equitable remedy. And the courts have a series of decisions about when they compel people to do work for others. And it's not something that the courts frequently do and often are uncomfortable at doing. They say that it involves supervision. On the other hand, of course, those sorts of work orders we are well able to supervise, in the sense that if somebody doesn't comply, then they can use what we call renewal to bring the proceedings back and convert the work order into a money order if the works aren't done within the required time. So, but in terms of appeals, there are legal issues often there about the terms of the contract and so forth. They tend to be a bit of an all or nothing appeal, particularly where repudiations come into play. So, you know, you have a homeowner who gets sick of the builder, who says you're fired, in true Donald Trump fashion, usually says it 6 times. Then, of course, the builder says, well, no, you can't fire me. You could only suspend the contract. I could have suspended the contract, but you don't have any rights. You didn't pay me. So you have those sorts of legal issues as well, and they become, of course, fundamental to whether or not there was an obligation, for instance, to complete the work. Often the experts told to make the assumption there was no obligation to complete the work because the contract was terminated. No evidence in relation to those things. Again, a fertile area for appeals and for consideration by the appeal panel. You do have complicated cases. I did deal with an appeal, I think it was last year, where there were findings concerning drainage, whether or not there had been backflow up a drain because of a surcharge in water. Some of those things the appeal panel looks at as well. But usually those sorts of factual redeterminations by the appeal panel need some fairly persuasive evidence. Because this division has a particular provision which seeks to cut down appeals, there's an extra hurdle to get over, so that you only get leave to appeal. And because of what's said in Schedule 4, Clause 12 of the NCAT Act, you only get leave to appeal if the party seeking to appeal may have suffered a substantial miscarriage of justice because the decision was not fair and equitable, against the weight of evidence, or there's significant new evidence that wasn't reasonably available. Now, against the weight of evidence is a little bit in the eye of the beholder. You need something, bearing in mind there's a filtering process. The appeal panel's consistently taken the view that there needs to be a good reason to interfere with somebody's conclusions on the facts. As you know, you can have 2 poorly explained expert opinions which need to be evaluated, and ultimately the tribunal doesn't make a guess, but the tribunal seeks to assess, by reference to other surrounding evidence, what's the more probable opinion which should be accepted by reason of the analysis. So coming back to what I said before, the analysis and the explanation to enable rational assessment is a critical feature of a good expert's report. And of course, presenting it in a way, if I go back to the example you were given before, where you've got an hysterical homeowner who wants everything, including to string the builder up on a high post outside their house, it is a matter of getting that focus in the expert's report on what are the real issues, so that that evaluative exercise can be undertaken.
Yes, Senior Member. Just a question. We last week had the privilege of having Matthew Press give a couple of speeches to consultants, which was great. The thing that I got out of it was that to assist the tribunal, it would be a great help to have the defects put into either the major or the minor defects category. Is that of an assistance if they're separated?
Depends. If there's a time issue, it is. As you know, under Section 18 capital D, I think it is, there's the provision, it's either D or E, I'm sorry, it is late in the day and I have forgotten. I do have the book beside me, but I won't pull it off the shelf. Right, but you've got to, if there's no issue about time, then it's not necessary. But it is useful to try and categorise defects. Often a theory as to what has given rise to a defect might apply to several defects across the building work. So if one's able to categorise them in that sense, that it helps. But usually whether it's a major or minor doesn't really make a lot of difference. The other thing though that does make a bit of difference and where people can burn a lot of money is the time spent on smaller items. So again, a little bit of proportionality needs to be considered. Hopefully the tribunal in its directions recognises some of that as well.
Okay. Mark, okay. On Graham.
Sorry,
Graham's
Rob.
Hand up.
Just a quick question, leading on from David, I suppose. David Chandler, in conjunction with Matt Press as his speaker, I suppose, he's running his broom through Class 2 buildings at the moment and trying to build bring a lot of builders in line. And this will filter through, well, what he believes, leading on from what he was saying last week, that's going to lead to a lot of other classes of buildings in the future, which will come down to the domestic dwellings that we're involved in. I just wanted your opinion on licenses and building consultants and having them licensed, and what's your thought? We were once licensed, it was taken away from us through the Labor government back in 2011 or 14, whatever it was. We're trying, I suppose, as an industry body, to raise the level of building consultants and their qualifications, etc. What's your thoughts on licensing?
We've got that. It's really a sort of policy issue in one sense, but I guess when people have asked me, I've not been that enthusiastic with the idea of having to have licensed consultants for this reason. I think that the people who are technically competent may or may not want to get into the work, but one of the problems when everybody has to be licensed is that it can make the exercise more expensive, but it can also narrow the number of people that you might be able to approach to get some assistance, which can of course drive the expense up for the parties. I think that the critical issue is the qualifications of people to give the evidence, and if you like, from decision-making bodies such as our own, to be able to promote and explain to the experts what good expert evidence is all about and what the role is. Hopefully in doing so and evaluating reports, people can see that we're trying to make appropriate decisions based on proper evidence rather than simply some sort of random or unexplained assessment by reference to somebody who frankly doesn't have the qualifications and so forth. But licensing, one of the problems that sort of come out of Sydney Towers and things like this is that a number of problems have been experienced in the industry because of these catastrophic or major problems with a few building works which have become notorious over the last couple of years. My sort of personal view is that when you get to the tribunal, it's all a bit late, and if people wanted to focus on solving these problems, I think it's ensuring the quality of building work and ensuring, particularly on the more complex and expensive projects, how do you properly assess the works as they're done, as opposed to bring them to the tribunal or a court when everything's gone pear-shaped. So that's my sort of area of focus. Really would be, if I was looking to be involved in the regulatory side, would be upon the construction rather than the sort of post-mortem that occurs when things go bad.
As I do. Thank you.
Mark, I just want to say thank you very much for